Thank you, Anna. Good afternoon, everyone. So thank you for those of you who responded in the chat. So we know that you can hear us and see us. If for some reason you cannot, you could just send us a message in the chat, although, of course, if you can't hear me, you won't be hearing this. But hopefully everyone is on board with us and can see and hear. So as Anna mentioned, I'm Simon Stapleton. I'm an elder law attorney here in Charlottesville. We also have offices in Richmond and in the Valley, in Stanton, and I help folks throughout the state. So I'm going to go ahead and share my screen here. So you'll be able to see the presentation, and Anna, you can see my screen now, correct?
Yep.
Great. Okay, perfect. So let's go ahead and get started. So this is what we're all about, long-term care planning workshop today, talking about how to prepare for healthcare in 2022 and beyond. Very soon, of course, it'll be 2023. My first question, and again, if you would use the chat feature for this, is to ask you, why are you here? So if you're here planning for yourself or yourself and a spouse, go ahead and enter in the chat, if you would please, the word self, S-E-L-F. And then that way, this just helps me to understand why you're here. And that helps me to know where to focus our time today so it's most beneficial for you. Thanks, Donna. Thanks, Susan, for that. And thank you, Dave. And so for Jennifer, thank you. Yeah, that's quite common. So oftentimes folks are here planning for themselves as well as perhaps an elderly parent. So we'll certainly make sure that we cover both those issues. So anyone else like Jennifer who's here planning for a parent or another loved one, just go ahead, if you wouldn't, type in the chat parent, and again that just helps me to see where we should spend our time today. So let me. Why are so many people concerned in this area? Well, the slide in front of you, these are some of the reasons. Of course, we're all getting older, our life expectancies continue to increase. If we think back to 1900, so 120 years or so ago, the average life expectancy back then was 47, believe it or not. So a lot of the issues that I deal with now today in the daily practice here, issues such as Alzheimer's, other forms of dementia, those really didn't exist back then because folks didn't live long enough to experience that. But they certainly are prevalent, of course, today, unfortunately. And you hear about this on the news more. There are more seniors now. It's becoming a bigger and bigger segment of the population. I saw a statistic that there are 10,000 baby boomers turning 65 every day in the US. So that's an awful lot of people. So again, you know, these areas are more and more of an issue for a greater number of us. Now, it won't surprise you to hear that this can be expensive, of course, especially if we're talking about care outside of the home, care in a nursing home. So the blank there in the first bullet average costs of a nursing home in this area for a month can be anywhere $7,000–8,000 a month. So for many of us, even if we had the ability to pay that 90 or 100,000 a year for a nursing home, for many of us, even if we had those kinds of savings in the first place, how long would it be before we lost everything and we were down to the poverty level? For most of us, not long at all, before our life savings would be gone altogether. And the key words here are in the second bullet: without advanced planning. So good for you all for being here today and starting to learn more and find out more about that planning process. Because of the type of work that I do, I really think that this is a true statement, that the greatest financial threat to most of us is this cost of long-term custodial care. And what I mean by that is care outside of the home. So an independent living facility provides the lowest level of care, and then assisted living. And there are various levels of assisted living that local facilities provide here, including memory care. And then the highest level of care is a nursing home. And I went over some of those costs for the average cost of a nursing home for a month. Expensive business. So the question then becomes, how do we pay for it? Well, what about Medicare? Will Medicare pay for a nursing home? No, it won't. Typically, what Medicare will pay for is we have a stay in a hospital, typically, and then some rehab. And for that rehab, Medicare will pay up to 100 days. So not 2 or 3 years, but only 3 months, a little over 3 months is the maximum that Medicare will pay for. Then after that, we have to qualify for Medicaid to receive any kind of government help. But unlike Medicare, we don't just qualify for Medicaid automatically. There are strict asset as well as income limitations to qualify for Medicaid. Now you see the second door there is the VA, and I don't know if we have veterans on the webinar today, but certainly under the right circumstances, the VA has some useful benefits for veterans, for wartime veterans. We'll talk a little bit about that. What about private insurance? Anthem, Blue Cross, Optima, will that pay for the nursing home? No, it won't. So it really comes down to us, you and your family, paying for the care if none of these other options are available. And we refer to that as private pay. In other words, spending down your own assets. And another way, of course, to pay if you already have it is long-term care insurance. That can be expensive, although certainly not as expensive as a stay in a nursing home. We are seeing those long-term care insurance premiums go up, and people, of course, are concerned about those increases. But I always tell folks, please reach out, please contact me before canceling any of those long-term care insurance policies, because of course, once you cancel them, then usually it's not possible to renew, to reinstate them. So that's a conversation I have frequently with clients, is what to do with those insurance premiums. Excuse me, excuse me. Sorry, frog in my throat. I mentioned earlier there are benefits for veterans. It's a benefit that you may or may not have heard of, referred to as the aid and attendance pension benefit. And the benefits are quite generous. Some of the numbers are on the screen here. 21, almost 2,200 a month for a married veteran that needs care, needs medical care, what is referred to as ADLs, so activities of daily living, what we do every day from getting out of bed. So mobility, transferring, dressing, showering, eating, toileting, etc. When a veteran needs help with two of those activities of daily living, that assistance is available. However, one thing that I wanted to mention, to stress, is that the VA is introduced that, like Medicaid, the VA now has a look-back period. And for the VA, that period is 3 years. So what that means is that if we're going to, for example, set up a trust to protect the veteran's assets, then that needs to be done at least 3 years ahead of time before the veteran is eligible for care. So again, that's why it's important to plan ahead. One reason is this look back period, which also applies with Medicaid, which I'll mention as well. So 3 years for the VA is the number there. Now, I'm going to be talking today a little bit because of how you replied in the chat, going to be talking a little bit about crisis planning, as well, of course, as planning ahead. So what I mean by crisis planning is someone is already in a nursing home, or the nursing home stay is on the horizon. So crisis in terms of we're in a nursing home, or we may very well be there soon. So one of the options that we definitely look at in that situation in crisis is Medicaid, what we call Medicaid planning. Now, those of you that are here planning ahead for yourselves today, please don't tune me out here while I talk about this crisis Medicaid planning. The reason why I say that is because these Medicaid rules, they determine how we plan ahead as well. So for those of you in that situation, it's important to have at least a basic understanding of these Medicaid rules. So in Virginia, in virtually every state, Medicaid does not pay for independent living or assisted living. Medicaid only pays for stay in a nursing home. But as I mentioned a moment ago, it doesn't happen automatically. We must meet strict income as well as asset limitations to qualify for Medicaid. And as you see on the screen, there are exempt assets as well as countable assets. Two different types there. So as far as exempt assets, by far and away for most of us, the biggest exempt asset is your house, your residence. Although, caveat warning here, the house is only exempt as long as one of the owners is living in it. So if it's a husband and wife, a married couple, house is exempt, but only as long as one spouse is living in it. A vehicle, a car, one vehicle is exempt, prepaid funeral expenses, a very small amount of life insurance, and household goods, they're exempt. So what's countable? Pretty much everything else. So any savings that you have, stocks, bonds, mutual funds, retirement accounts, IRAs, 401ks, etc., those are all what Medicaid calls countable assets. So I give an example here, Mr. and Mrs. Johnson, married couple, and they have $246,000 in savings, as well as they own their home. So in our example here, John, he's going to be the one going into the nursing home. So how can we protect some of the assets? Well, we can. As I mentioned a minute ago, John's in the nursing home, but Agnes, she's still at home living in their residence. So because she is in the home is protected, meaning Medicaid cannot put a lien on it or do anything with the house. However, if Agnes got sick or if for some reason she had to move out of the house, then the home is no longer an exempt resource. But for right now, we know we can protect the home. Agnes is living in it. Now, Agnes also has what's referred to as a CSRA, which stands for Community Spouse Resource Allowance. And what the rules say is that Agnes can keep half the assets up to a maximum of 246,000. I'm sorry, let me restate that. Up to a maximum of 123,000. So that's why I use these numbers, because 246 is half of 123. So we know Agnes can keep that amount of money, 123,000. Now, while we're putting this planning in place, it takes a month or two. Of course, John's in the nursing home, we have to pay the nursing home. Other exempt assets that I mentioned before, we can prepay their funeral expenses. They only have an old car, so we're going to buy them a new car. That's exempt. Again, the house, as long as Agnes is in it, is exempt also. So now's a good time to fix up the house, new roof, new heat pump, whatever it may be. All those things, that's referred to as the Medicaid spend down. So we're spending down that money, putting money into the house, doing repairs that are needed. So that's a good thing to do. Also good to do is pay off any debts, because the Medicaid doesn't look at debts, they only look at assets. So now's a good time. They have a credit card, smaller home equity line. Now's a good time to pay that off. That can all be part of the spend down. Another thing that we can do is we can purchase for Agnes what I call here a specialized financial product. That's a very specific type of annuity. Sometimes it's referred to as a Medicaid compliant annuity. So don't worry too much about the math here, but the difference between, on the left side, the difference between 123,000 and 2,000, of course, that's 121,000. So with that money, we're going to buy, in this case, for Agnes, we're going to buy a 10-year annuity. So divide that by 10, that's the annual payout, divided again by 12, that's a monthly payout. So what we've done here is we've increased Agnes's income by $975 a month. So that's a good thing. She has more money coming in. But more importantly, that 121,000, that's exempt for Medicaid purposes, because that's in this special type of annuity in payout. So if we go back to the beginning of the example, Agnes, the house is protected, the 123,000, Agnes keeps that. The 121 is protected in the annuity. And John, as the Medicaid recipient, he can keep $2,000. So once this planning is in place, all the assets are protected, John will qualify immediately for Medicaid. So just an example there of what we can do if you're planning for a parent or a loved one, even if they are in crisis, oftentimes we can protect all those assets, even, as I say, in a time of crisis. So a couple of other things to mention here about Medicaid is, I mentioned with the VA, there is a look back period of 3 years. Well, if we're planning for Medicaid, if we're setting up a trust to protect the assets, that penalty period used to be 3 years. It's now 5 years. So again, important if we're planning with trusts or using other tools to protect those assets, important again to plan ahead, to do that ahead of time, hopefully before we're in a crisis situation. Now, just to be clear, the annuity and those other strategies that I mentioned, they are not subject to the 5-year rule. But if we're planning ahead, then that setting up a trust, for example, that is subject to that 5-year look back period, which I mentioned. Okay, so that's a brief overview of Medicaid and how those rules work. What I'd like to talk about now, excuse me, what I'd like to talk about is planning ahead. And I think from your answers in the chat, this applies to most of you. So, okay, I'm healthy now today. What can I do to protect my retirement, my other assets? How can I protect that for myself? And of course, if we're married, our spouses, as well on down to children or even grandchildren. As I don't know about you folks, but most of the people that I talk to, they say I would rather, for instance, I'd rather help a grandchild out with their education than see the money go to a nursing home. So we're going to talk a little bit about how to do that and how not to do that. And this slide here falls into the latter category, what not to do. We don't recommend outright gifts to children. Because what if that child or grandchild is too young to receive the money? What if, you know, I give my life savings to my daughter to look after? What if she later on, she runs into creditor problems? Of course, we hope not, but gets divorced later on. And certainly we hope not drug or alcohol problems, but none of us know the future. So those are all dangers. And, you know, I'm not talking about $100 at Christmas here, but, you know, larger gifts to children and grandchildren, we avoid those because they're penalized under the Medicaid rules should we ever need to apply later on. So generally speaking, gifting to children, that's a no-no. Another one, which sounds good, which sounds very simple, but we need to be cautious about, is what I refer to as the I love you will. So what those wills say is, husband's will says I leave everything to my wife, but if she passes first on down to the kids. Same thing, the wife's will says I leave everything to the husband, but if he predeceases me, on down to the children. Well, that sounds simple enough. What's the problem there? The problem is that we don't know what situation we're going to be in when we pass. So if we think back to my example with John and Agnes, let's say Agnes is the one who passes first. If they have a will like this, what does Agnes's will say? Where does the money go? To John. Where's John? John's in a nursing home. Well, that's going to be a problem because let's say he's a veteran, he's receiving veterans benefits. Well, now he just has received all the money from Agnes. That's going to kick him off that benefit. So bad result there. If he hasn't applied for a benefit yet, he's not going to be able to do so because, again, just having received the other half of the assets from Agnes under her will, so bad result there. Another thing that we have to be careful of, where we see plans frequently fail, are beneficiary designations. So again, using John and Agnes as an example, John's will says he leaves everything to Agnes, and John passes away before Agnes does. But after the will was done, John had set up all these different accounts, these different beneficiary designations. So first of all, they have a joint account. Well, that one's not a problem because that goes automatically to Agnes. Why? It's a joint account. It goes to the survivor when John passes away. But other beneficiary designations that John has set up, he has an IRA, life insurance, POD, TOD. You may be familiar with those. Those are called either payable on death or transfer on death accounts. And he set those up to the kids to go to the children. So even though the will says everything to Agnes, those beneficiary designations are going to override what the will says. So the IRA, the POD, the TOD accounts, the ITF, the in trust for accounts, they're all going to go to the kids, and Agnes is only going to receive that little joint checking account. So very careful, very important to be careful when we're doing this planning, that those beneficiary designations are another thing that we take into account. So what could John have done instead of having all these different beneficiary designations? What he could have done is made all these different, the IRA and all these other accounts, made those payable to a trust. And then what the trust would say when John passes is, if Agnes is alive and healthy, then not a problem. The assets in the trust go to Agnes. But let's say when John passes, Agnes is in a nursing home. Well, then the trust gives us more flexibility. The trust could say the assets go to the 3-to-1 or all three of their children for Agnes's benefit. But then what happens then is the money goes to the kids, and then they use that money to pay Agnes's bills instead of going directly to Agnes if she's in the nursing home where we don't want her receiving additional assets. So in that situation, the trust gives us a lot more flexibility than just a beneficiary designation. Okay, so in addition to planning with a trust, in addition to setting up your plan in the right way in the first place, another thing that we do, if you decide to work with us, which I hope you all will, another thing we do is we have what we call our maintenance program. So what that does is we get together annually, we review your plan, make sure if you have a trust, make sure that all the accounts are in the trust, everything's designated properly, real estate, that's been transferred to the trust, so everything's protected. As I say, we review that annually. If you have changes in your family circumstances, perhaps a new grandchild, that kind of thing, you want to name a new agent under a power of attorney, those are all the kinds of things that we review. We call it our client and family care plan, or an annual maintenance program, because it's very important to, of course, to set up the right plan in the first place, but equally important to review it regularly. So this is an important slide here because, we call ourselves elder law or elder care attorneys. And I used to refer to myself 20 years ago as an estate planning attorney. Well, what's the difference? The difference really is that if you'd have come to see me 20 years ago, we would have focused on this question, this first question at the top of the screen. I would say to you, what do you want to happen to your assets when you die? Who do you want the money to go to? When? How do we avoid or minimize estate taxes, capital gains, etc., etc.? Now, of course, those are all very important questions, but as you can hear, they're all focused on when you pass away. Now, the question I ask, first of all, today as an elder law attorney is, I say, what happens if you don't die? Of course, we're all going to die eventually, but what happens if statistically, this is very likely, that before we die, we become ill, and some of us, certainly statistically, about 50% of us will require this long-term care stay. So that's where we're going to focus our question, first of all, is what happens if you require long-term care? Because if you think about it, if all the money goes, all your assets, all your savings are spent in the nursing home, then it doesn't really matter. The top question, what happens when you die, doesn't really matter if all those assets have been lost to the nursing home or in other medical expenses. So that's why this is where we focus first, is what if we have a long-term care need? So as a result of that, we're going to redo the estate plan. So let's take a look at, we call this building our legal foundation. Let's take a look at what this might look like. And I encourage you, if you haven't done so already, I encourage you to make some notes here, because this is important stuff. So what does the legal foundation consist of? Well, the 4 documents listed on the screen here. So 2 different powers of attorney, financial as well as medical, and then a will and a trust, and we'll talk about both of those. So first of all, very important, often overlooked, is a financial power of attorney. And this is an important document. If we go back to the example of John and Agnes from earlier, so John is going to name Agnes as his power of attorney, meaning if he's not able either physically or mentally at some point in the future, if he's not able to write checks, pay bills, etc., then the power of attorney says that Agnes, as his agent, can do that for him. But they're often traveling together. So what happens if something happened to both of them? Let's say they're in a common accident. Well, then they're going to name, in that case, Justin, their eldest son, they're going to name him as a backup or successor agent. John does in case Agnes is not available, and same thing, Agnes will name John, and then Justin as a backup or successor in case John's not available. And then equally important, of course, excuse me, are the healthcare documents. So first of all, there is a medical power of attorney. So again, if I'm not able to make medical decisions myself, who do I want to name for that? John names Agnes, Agnes names John to make those medical decisions if they're not able to speak for themselves. And Katie, their daughter, she's a nurse, so they're going to name Katie as a backup agent under the medical power of attorney. Then another very important document is a living will. That's the document that says if I'm on a life support machine, if I'm in a permanent coma, what do I want to happen in that situation if there's no chance of a meaningful life? Many people in that situation say they don't want to be kept alive artificially by machines. So that's what the living will says, what you want to happen in those situations. Personal care plan again, what I want to happen to me medically if I can't speak for myself. And then the last one is a HIPAA release. What's HIPAA? HIPAA, those are the healthcare privacy laws. So they basically say that no one without my permission can see my medical records. So when we're doing this for families, we say my spouse, my kids, whomever I choose, brother, sister, the person making my medical decisions obviously needs to be able to see my medical records. So that's what we call a HIPAA release, so that that person making the medical decision for me can have access to those medical records. I mentioned a moment ago wills and trusts. So a question that I often ask is, if you have a will, does a will have to go through probate? Some people answer no to that question, but actually the answer is yes. In fact, a will is the very definition of probate. If you have a will, the will has to go through probate before the money, the assets get to your loved ones. Well, what is probate? In a word, probate is a pain. It's all these nasty P's. It's pricey, it's public, meaning if John passes away, Agnes has to go down to the courthouse, record the will, which is a public document, just like a deed. She has to fill out all these forms, do an estate inventory and an accounting. It can take weeks or more often months. It's expensive, and a will is prone to challenge. So that's the bad news about the probate process. The good news, however, is that if we have a trust, the trust completely avoids the whole probate process. But because of what we've been talking about earlier, we want to make sure that we have the right type of trust set up ahead of time, one that's not going to cost us valuable VA, or if we need the Medicaid benefits later on. So in terms of different types of trusts, there are hundreds of different types of trusts out there, but they fall into these three main categories on the screen here. A revocable trust, asset protection trust, but before I talk about that, I'm just going to take a break for a minute on the slideshow. And before we talk about trusts, I want to give you an example of one other legal concept. So the legal concept that it's important to understand is what's referred to as debtor-creditor law. So let's say John passes away, and his entire estate is represented by this dollar bill, okay? So this dollar bill, his estate, is going to go to Agnes. Now, we've got a couple of different choices here. We can just give the dollar outright to Agnes. However, what debtor-creditor law says is that if Agnes has full access to this dollar, then so do her creditors. Well, I explain that to clients. They say, okay, no big deal. We're not worried about that. We don't really have any creditors. But when I say creditors, I'm talking about not just a creditor now, but a future creditor, like a hospital bill or a nursing home bill. So that's debtor-creditor law. So when we give Agnes, instead of just giving Agnes the dollar, what we're going to do instead is we're going to put the dollar in a trust for Agnes. Agnes says, well, I'm not sure I like that. Why are we putting the dollar in the trust? We say, Agnes, don't worry, because what we're going to do is we're going to make you, Agnes, the trustee, the manager of the trust. So what that means as trustee you can come in and you can take the dollar out at any time. Okay, well, that's okay. But what did we just say about debtor-creditor law? If Agnes can take the dollar out, who else can potentially? The creditors, right? Well, what I just described to you there is number one on the screen, which we'll go back to sharing my screen here. What I just described to you is what we call the open box. Okay, the lid of the trust is open. We refer to that, number one, the revocable living trust, as the open box. Agnes says, well, you know, I don't like that. Why do we have an open box here? I don't want the creditors to be able to get in. So we say, okay, Agnes, well, here's what we'll do instead. We'll close the lid, we'll turn the key, and we'll give you, Agnes, a co-trustee. Who is that? Well, that's whomever they choose when they set up the trust. So they've chosen Justin, their eldest son. They've chosen him as a co-trustee with Agnes after John passes away. So just to give you a couple of examples here of how number two, so remember we're talking now about number two, the closed box, the asset protection trust. How does Agnes get asset protection? Well, example number one, Agnes calls up Justin, who's now the co-trustee, says, hey, you know, Justin, I've been driving around in that old Buick. It's finally stopped. It's given up. Please open up the trust. We need to buy me a new car. What does Justin say? Justin says, of course, Mom, it's your trust. It's your money. So they open up the trust. Agnes buys her new car. She goes off driving down the road in the new car. She's happy. We close up the trust again. Now, example number two, now many years go by, now not such a happy example. Agnes calls Justin, the co-trustee from the nursing home, says, hey, Justin, you know, here I am in the nursing home. I've paid for December, but soon it'll be January. It seems like all they care about is money. I'm going to have to pay January, February, March. I don't know if I'm ever going to be able to go home. Please, Justin, let's open up the trust and pay the nursing home. What does Justin say? Justin says, no, Mom. Remember, this is why you and Dad set up the trust in the first place. Again, we're talking about pre-planning now, so we're assuming the trust has been in existence for at least 5 years. So Justin says, you know, Mom, if we have to, we can apply for Medicaid to pay the nursing home. But this money here in the trust, this is set aside for you. If there are things that you need that Medicaid doesn't pay for, then that's the money in the trust is for. And of course, Justin knows that John and Agnes, when they set up the trust initially, they wanted to have an inheritance go down to Justin and his two siblings. So Justin reminds Agnes of that, you know, this is money that you wanted to pass down to us eventually. So again, that's what the trust is for. Number two there, the closed box, the asset protection trust. And then very briefly, just mention this quickly. Sometimes folks have large IRAs. And of course, because IRAs have different tax treatment, then sometimes what we'll do with a large IRA or 401k is we'll just have a trust purely for those retirement assets because they have different tax treatment to make sure that they're respected, that the taxes are treated properly by the kids or who's ever inheriting the IRA. Okay, so again, the first level, if you will, the open box, the revocable trust. Now, bear in mind that even though it is an open box, because it is a trust, any trust avoids probate. Minimizes estate taxes. If that's a concern, we can delay distribution to children, especially if we have a disabled or a minor beneficiary. We can have what's called an SNT, or a special needs trust, for a beneficiary like that. Now, the next level up, the next level of protection, number 2, the asset protection trust, the closed box. Sometimes you may see that referred to as a Medicaid trust. Now, that is true. My clients certainly do use that for those purposes. But just to mention that that is not the only reason to have the asset protection trust by any means. For example, I have clients, they have rental property. So we go ahead and put the rental property in the trust so it's protected, so that if there's an incident with a tenant or a guest in the rental, the clients are not being sued. The creators of the trust are not being sued personally by folks in the rental property because they personally don't own the asset. The trust does. Another example, clients who are physicians or in other high-risk professions will have a trust like this, again, to protect themselves from being sued personally. So what we say, as you see on the screen here, this is just like the RLT, the revocable trust, plus it has additional protection from creditors, from lawsuits, and then once the trust has been in existence 5 years, then we get that protection, Medicaid and the nursing home, so the nursing home doesn't have access to your assets if there's a long-term care stay later on. Number 3 here, the IRA inheritance trust, mentioned that's sometimes set up in such a way so that kids, other beneficiaries, take seriously that retirement income coming in. Okay, so to summarize here, the best way to protect ourselves and care for our loved ones is to develop this long-term asset protection plan. Now, for many of my clients, not for everyone, certainly, but for many, that includes the asset protection trust. As we've talked about, all trusts are not the same. The asset protection trust, that's the one, as the name suggests, that's going to protect your assets now while you're alive. Important for Medicaid, but important also for other concerns as well, asset protection in general. A question that often comes up when I talk about this is folks say, well, you know, this all sounds great, but do I still maintain control? And the answer is yes, you do. So because you are the trustee, the manager of the trust, you maintain control of the assets in and out of the trust. Your accounts can just stay where they are. So if you have a savings account with Wells Fargo, Bank of America, wherever, they stay in that institution. We just simply retitle that account into the name of the trust. And then the trust then replaces your will. And of course, in the trust document, you decide where your assets go after you pass on. You name children, aunts, uncles, your favorite charity, brother, sister, whomever. The trust says where your assets go after you pass on, or if you're married, after you and your spouse pass on. That spells all that out in the document. So in terms of next steps, where do we go from here? Before I talk about that, one thing I do want to mention, we like to be transparent. So one thing I want to mention is the cost of setting up this planning. What we say is that plans can range anywhere from $1,500 all the way up to $8,500 for a married couple if it's a complex plan. But the most typical situation that we see is we offer this, the third bullet here, this asset protection trust package, which is $5,500 for a couple or $4,500 for a single person. And I'll go over what the package includes. Some less common examples here if we have large IRAs, 2 trusts, etc. So this asset protection trust package includes, of course, the trust itself, the deed to your home. So we want to go ahead and put the deed to your house in the home now when we initially set up the trust. Why do we do that? Remember earlier when we talked about the example with John and Agnes, the home is only protected as long as Agnes is living in it. So what we're going to do now when we're pre-planning is we're going to go ahead and put the house in the trust so it's protected for later on. The last will, we do still do a will in this situation, but it's what we call a pour over will. And what that means is that any assets that are outside of the trust, the pour over will literally pours those assets on over into the trust. So we have a vehicle, for example, that's outside of the trust. What the pour over will does is add that to the trust so we avoid probate on any assets, even a vehicle, or perhaps a bank account that was not already in the trust. Then the other documents that I mentioned, the general financial power of attorney, medical power of attorney, the living will, the HIPAA release, the release of medical records, that's all included in the package. And again, you see the fee there. So just to give you an example, let's say your net worth is $550,000. So say you own a home that's worth $300,000, you have $250,000 in savings. So if that's a married couple, because $5,500 is 1% of that net worth there of $550,000, costs about 1% to protect your entire estate, because again, $5,500 is 1% of that number. Just an example there. Okay, so one other quick thing that I want to mention. We mentioned our client and family care plan, our annual maintenance program. Some of the benefits of that are listed on your screen here, including, most importantly, peace of mind to keep your plan up to date as we go along. That is optional, as it says. The fee for that is $495, so $495 a year, including consultations with me, keeping everything up to date. So, because you have all been on the webinar today, we do offer a free consultation to folks that have been on the webinar. And this is what we ask you to do in preparing for the consultation. We do have some forms that we just ask you to fill out ahead of time before the consult